Well, with that, on to our top focus story. Now, in a big development in the Krishna Janmabhoomi-Shahi Idgah Mosque case in Mathura, the court has ordered a survey of the site. In fact, in its order, the Mathura District Court has said that controversial site must be surveyed and its report must be submitted to the court by the 20th of January. In fact, a notice has also been served to all the defendants in the case. Now, remember, this is based on a suit which was first filed in the Mathura Civil Code in 2020, which sought the removal of the Shahi Idgah Mosque that is adjacent to the Krishna temple complex. Now, the Hindu side has sought a transfer of 13 acres of land to the temple trust, while the suit was dismissed by the civil court. This was in 2020. This order now has been challenged in the district court, which has now ordered a survey of the site, which is going to be along the lines of Gyanvapi.
मथुरा की कोर्ट ने आज जन्मभूमि में सर्वे का आदेश दे दिया है। हम कोर्ट का आभार व्यक्त करते हैं। समय आ गया है, कोर्ट का फैसला आएगा। और जहां तक प्लेसेस ऑफ वर्शिप एक्ट की बात है, जो कांग्रेस की सरकार ने 1991 में बनाया था, उस पर भी 12 जनवरी को कोर्ट में सुनवाई है। हमें पूरा भरोसा है कि प्लेसेस ऑफ वर्शिप एक्ट खत्म होगा, सुप्रीम कोर्ट उसको खत्म करेगा। और इस बीच मथुरा की कोर्ट तब तक सर्वे करा के जो एविडेंस है उसको भी कलेक्ट करा लेंगे और आगे डे टू डे हियरिंग होगी और अगले 2 साल के अंदर मथुरा में भव्य निर्माण का रास्ता साफ हो जाएगा।
अब मथुरा जी की जो बारी है, कृष्ण जन्मभूमि की जो बारी है, और उसमें निर्णय दिया है कोर्ट ने। यह बहुत हिंदुओं के लिए शुभ संकेत है कि निश्चित रूप से अब सर्वे होगा और वहां पे अवैध बने ईदगाह या तमाम चीज़ों की जो सर्वे होगा उसमें निश्चित रूप से हमारे मंदिर के अवशेष और मंदिर के प्रमाण मिलेंगे, जिसके आधार पे अवैध निर्माण वहां से हटेंगे और भगवान कृष्ण का भव्य मंदिर का निर्माण वहां होगा। अब इसके रास्ते खुल गए हैं। निश्चित रूप से इस सभी पॉलिटिकल पार्टी, चाहे पक्ष हो विपक्ष हो, सबको इसमें साथ देना चाहिए, सबको समर्थन देना चाहिए।
Meanwhile, Muslim clerics have said that any petition that is filed now is unconstitutional, that this is illegal. In fact, judges should not accept such petitions and dismiss it because of the Places of Worship Act.
देखिए, इस वक्त जो भी काम हो रहे हैं, जब से ये भाजपा सरकार आई है, चाहे यूपी में हो, केंद्र में हो या किसी भी स्टेट में, तो ये संविधान की तो बात करते हैं, लेकिन काम जितने भी कर रहे हैं गैर संवैधानिक कर रहे हैं। सिर्फ बाबरी मस्जिद को उसमें अलग रखा गया था, इसलिए कि उसका पहले से केस चल रहा था। अब अगर कोई पिटीशन दाखिल भी करता है किसी भी मस्जिद के लिए, किसी मंदिर के लिए, किसी भी धर्म स्थल के लिए, वो गैर कानूनी है, वो संविधान के खिलाफ काम कर रहा है, वो हिंदुस्तान के कानून के खिलाफ काम कर रहा है। जजों को ये ऐसी पिटीशन लेनी, एक्सेप्ट नहीं करना चाहिए, उनको उसी वक्त एप्लीकेशन को फाड़ के फेंक देना चाहिए।
With that, some big breaking news which is coming in after Gyanvapi Mathura survey has been ordered, but this hasn't gone down too well with Asaduddin Owaisi. The AIMIM chief has tweeted about it. He says after Babri Masjid judgment, I'd say that it has emboldened the Sangh Parivar's mischief. In fact, he says that Mathura Court has now appointed a commissioner to examine evidence inside the Shahi Idgah complex. This is despite the Places of Worship Act prohibiting such litigation. It's also despite the fact that the masjid and the adjacent temple have a written settlement resolving the dispute. Please don't preach, give and take when one side is interested in constantly targeting Muslims. Well, there you have it, a complete communal turn which has been given and injected into a verdict coming in from the court. But let me go across to our panelists to help us understand who really is crossing the line here. Vishnu Jain is joining us, a lawyer. We'll be going across to other panelists as well. But Vishnu Jain, it's important for us to come to you because what do you think is going to be the significance of a survey such as this? Because there are many like Asaduddin Owaisi who are now coming out and say that this is Hindu appeasement, that this is something which is being done at the behest of the Sangh Parivar and it is their mischief to target Muslims.
See, courts of law in this country do not work on the basis of any political party or on the instructions of any political party or social organization. That is point number one. We have gone in the courts of law. We have not made any political statements outside the court of law. That is point number two. Third point is that please correct the facts. It is very, very important that on 19th of May 2022, the District Court of Mathura has already passed an order whereby it has been held that the Places of Worship Act and Waqf Act is not applicable in the matter. And against that order, the Shahi Idgah committee is before the Allahabad High Court. So the question of applicability of Places of Worship Act has already been won by us before the Mathura Court on 19th of May 2022. And the fourth point is that the importance of this survey is that all total 13.37 acres of land was purchased by Raja Patnimal in 1815 by the British government in an auction purchase. It was purchased by an Hindu Raja in 1815.
Right.
That property was in turn transferred to Pandit Madan Mohan Malviya, who had ultimately formed a trust known as Shri Krishna Janmabhoomi Trust. Now today the court wants to know by the officer of the court that what is the current status of the property in issue, how much land who is possessing, and what will be the side plan of the property in question. And this is just a very, very legal exercise which has been conducted within the domain and purview of Order 26, Rule 9 and 10 of the CPC. So there is no question of any appeasement or any all these kind of debates which I was just hearing or comments. It's a legal exercise, and through the legal process.
So in this legal exercise, two questions, Vishnu Jain. First, the 1968 agreement which was made with the Shahi Idgah. Why would you say, and on what grounds have you challenged it in court? And second, when you say the Places of Worship Act has already been it's already been given by the court that it does not stand in this case, that is also open to legal challenge in higher courts, isn't it?
Yes, I will answer both the questions. Point number one, the compromise of 12th of October 1968 was not entered into by the lawful owner. The lawful owner of this property, as I explained in my previous comment, was of Shri Krishna Janmabhoomi Trust. Shri Krishna Janmabhoomi Trust was the original lawful owner because the entire property through the original owners was transferred to Shri Krishna Janmabhoomi Trust. A fake trust was formed and the name of the trust was Shri Krishna Janmabhoomi Seva Sangh, which is very similar name to Shri Krishna Janmabhoomi Trust. And Shri Krishna Janmabhoomi Seva Sangh entered into a compromise with the Shahi Idgah, not the Shri Krishna Janmabhoomi Trust, which is the original owner of the property in question. So therefore, this compromise is illegal. And let me tell you, the Allahabad High Court in 1997, Allahabad page number 620, SCC online, has already said that this compromise is illegal and you can challenge this compromise before court of law. And Shri Krishna Janmabhoomi Trust and Seva Sangh are two different bodies. This has already been held. So this permission and liberty was given to me by the Allahabad High Court, and ultimately the suit has been filed to annul the compromise of 12th of October 1968. Now coming to your second question, you had asked me a question that why Places of Worship Act is not applicable in the case. Because the fact of the matter is that after the implementation of Places of Worship Act, the so-called mosque has been created. Because the fact of the matter is that Places of Worship Act does not bar from ascertaining the religious character of a property. If suppose there's a, let me explain my thing through an example. If suppose in a mosque I go and enter and I put an idol, will the religious character of a mosque evade? Or suppose vice versa, if in a mosque, if in a temple, someone enters and offers a namaz, will the religious character of a temple completely change?
But the cutoff date has been set for 1947.
Exactly. So our point is that on 15th August 1947, this particular property was having all the antecedents and all the characteristics of a Hindu temple. And after the cutoff date, in violation of Places of Worship Act, the so-called mosque has been raised and the present structure has been given, which was validated by the compromise of 12th of October 1968. Therefore, the suit has been filed in the courts of law, and therefore we have won so far as the issue of Places of Worship Act is concerned, and the Honorable District Judge has held on 19th of May 2022 that the Places of Worship Act is not attracted in the matter.
Now, Vishnu Jain, you and interestingly your father, Hari Shankar Jain, the two of you have been at the forefront of trying to reclaim not just Hindu but Jain lands as well, as you have said, which have been destroyed over the years. If I'm not mistaken, about 102 such cases between the two of you that the two of you have been fighting currently. Just give us a sense, because this is the allegation which has been put again and again, that places of worship of Muslims, and this is something that Asaduddin Owaisi has just said, that places of worship of Muslims and Muslims as a community are being targeted, and now this is a Pandora's box which has been opened by the Supreme Court after the Babri verdict. How do you react to that?
It is absolutely erroneous, because the point in issue is, and I will request you with utmost sense of humility that please ask this question to Mr. Owaisi whenever you get an opportunity. That can he say as an Islamic scholar or as a barrister that he can demolish a Hindu temple and construct a mosque? If we can't say that, then ultimately we are fighting for those places where temples have been brought down. And if the temples have been brought down, and if there is proof in the history, and if there is proof in the ASI survey and expert opinions that yes, there was a pre-existing temple, then definitely we have the chance to restore it. My senior Mr. Parasaran had argued in Ram Mandir case in the Supreme Court that Article 13, Subclause 1 of the Constitution of India gives the right to declare that all those acts and orders which have been passed in the slave dynasty or in the slave period, all those acts and orders are unconstitutional, and the Supreme Court said that yes, if the sovereign recognizes all those acts, it can be rectified by the sovereign. And let me tell you that Indian judiciary is exercising one of the sovereign functions. Therefore, we are before today the Indian judiciary with utmost sense of humility that please restore our glorious past. Please give us Kashi and Mathura.
Well,
Please
that's a
give us
very
Goshala.
impassioned speech that you have made. However, that has not been enough to perhaps convince some of the other panelists who are also joining us here on the show. Allow me to introduce them as well. Stay with us, Vishnu Jain. We also have Vinod Bansal joining us, national spokesperson of the VHP, also Professor Atiq Ur Rehman, a political analyst. Now, Professor Atiq Ur Rehman, you've heard what Vishnu Jain has said. This is a court verdict. A court has ordered a survey. It is not religious in nature. The court is not going to be swayed by what ideology and what party is supporting what it is. The wisdom of the court, it has decided. Why inject a communal tone to this? Atiq Ur Rehman.
The wisdom of the court cannot be questioned. We believe, and I believe in particular, that the lower courts are being intimidated. This is a clear violation of the 1991 Places of Worship Act. Whether Mr. Vishnu Jain accepts it,
on what grounds are you saying
or
that,
does
Professor
not
Rehman?
accept.
Because courts are
And his plea-
integral to India's democracy. If you say that the courts and the judges are under pressure, why would you say that?
We have seen earlier that the lower court judges have demanded security for their families. This Hindutwadi forces on all the gully and nukkars in the premises of the courts and around it, they are intimidating the lower court judges. And that is why I request...
That is the case. Perhaps the judges themselves would get in. Vinod Bansal, would you like to answer that? If you're not happy with the judgment, blame the judges.
Definitely. You see, whenever any political leaders going to fearing the defeat, they blame the EVM. On the same lines, when they are nothing to do with the justice, they are blaming the judges. आप देखिए कि जिस तरह से अभी तो सर्वे का ऑर्डर हुआ भाई, the survey is to come out the trust before the people of the country. अब आप उस ट्रस्ट को रोकने की कोशिश क्यों कर रहे हो? सत्य को अन्वेषण से क्यों बचना चाहते हो? आखिरकार उस झूठ को कब तक दबाना चाहते हो? और ये भड़काऊ भाईजान के कहने पर, यह जो हैदराबादी जो भड़काऊ भाईजान है, आखिरकार उनके पिछलग्गू बन करके आप कब तक जियोगे भाई? You are the Islamic scholar. At least you are not supposed to do that. आप मुझे बताइए कि आखिरकार
I'll come to you, Mr. Atiq Ur Rehman. Vishnu Jain, you worked your way up. You worked in all kinds of courts, starting with the district courts, the high courts, the Supreme Court. Are judges under pressure to deliver a certain, to deliver verdicts which are going to ascribe to a certain ideology?
लगता है ये भारत के कोर्ट नहीं, पाकिस्तान और बांग्लादेश के कोर्ट को समझते हैं.
I respect Mr. Atiq Ur Rehman a lot, but I feel that this is a completely contemptuous remark, because the judges of this country are very, very powerful and very, very independent to take decisions without any fear or favor, affection or ill will. Now the point and issue is, I don't know what example Mr. Atiq Ur Rehman is citing of one lower court judge asking for security. It was a lower court judge asking for security because it was intimidated by a member of your community.
Yes,
Mr. Atiq Ur Rehman, please gather your facts right. I don't want to name the judge here on this national television, but this is the fact of the matter.
Yes.
Who had given threat to the judge of
Atiq Ur
Varanasi?
Rehman, who has been the provocateur, not just during the trial, but also after the verdict is coming out of the judge to order a survey. Atiq Ur Rehman.
Meghna, I and all of us do not have any right to take your viewers for granted. Times now viewers are quite, learned people to see what exactly they are being shown, and they are being intimidated too. But they will not get intimidated. 12th October 1968 stands null and void for Vishnu Jain ji also and Vinod Bansal Saab also. Then I am telling you, henceforth, in the years to come,
go to the court.
The Ayodhya
Why you are escaping? You are also the advocate of the country. Why don't you go to the court instead of instigating your community and the Islamic youths?
That will be done, sir. Your game plan is well understood by the people of India.
No, we don't have any game plan. We have been known picture and you see the Hindu community cannot be taken for granted.
And the people
किस give and take की बात कर रहे हैं? Which give and take?
And unfortunately, that is one of the problems. Now we have an order coming in from the learned court which says hold a survey. Even before we know what the survey is going to happen, what the survey's findings are going to be, there's already a political war of words which has happened. There are already those who are trying to block the survey. The simple question is, let the survey happen. Let's have this debate based on the facts which will be thrown up by the survey. Thank you so much for joining us, Atiq Ur Rehman, Vinod Bansal, as well as Vishnu Jain on the show. We are running out of time. Thank you so much for joining us. With that, a short break.